thank you very much. Let me next turn to Jon Cooper. Good morning.
Good morning to Councilman Allen and my Councilwoman Nadeau and the Council on the whole. My name is Jon Cooper. I come today to urge you to pass whatever version of these bills will in sealing and expungement, which will help returning citizens. I support this and the many other efforts on criminal justice reform, and I hope to have some discussions with you in these other matters in the future. The basis of my belief comes from my work and personal experiences. I teach a course on reentry at George Washington University, during which I've had the pleasure and sadness of teaching many students about the barriers to reentry for returning citizens. Of relevance today, their criminal record mostly bars them from many jobs as well as educational opportunities. By one study, for instance, 90% of colleges and schools look negatively on applicants with criminal records. And so while recent ban-the-box legislation was helpful, this does not go and prevent many of the problems that we see. While I recognize that in some selected instances, felonies should not be sealed or expunged, I believe that all misdemeanors and most felonies should be eligible for this treatment. I particularly like features in the present bills that allow review of offenses within limited and short time periods, and which have the rebuttable presumption that all offenses should be removed after 10 years. I note also that most credit reporting removes negative reporters much sooner than this. And so we have that. I personally experienced these problems. I was released after serving a sentence for a nonviolent felony plea almost 6 years ago. Although I was selected and found highly qualified for several senior jobs, my record resulted in quick rejections. While I accept full responsibility for my criminal offense, it's been a long time since 2007 when this occurred. And it really has barred me from coming back into many professional jobs. I will end this testimony with a quick story. I was accepted and served successfully in a one-year program as a senior environmental scientist with the DC Department of Energy and the Environment through a US EPA program. My background was fully disclosed. I was then offered another US EPA position. Lo and behold, my appointment was delayed. I then got an email from a security officer that they would not clear me for the position because I was charged with 7 offenses. All these offenses were dismissed by US District Judge Amy Barrett, but their presence by record led me to lose these positions. Expungement of at least the dismissed charges would have made all the differences here. And since the plea bargain offense was a low-level nonviolent offense, it should have also been expunged. Please help me and the many other returning citizens who have turned their lives around by adopting this important bill. Since the previous panel also mentioned talked about delays and really inferred, let me mention that bundled offenses really need to be handled very differently. I see many of my students and clients that have had maybe one piece of 7 bundled offenses acted upon, but they are often barred because of the other pieces of the bundle, and those bundle pieces are still brought up as though they were convicted for those bundles. And so that needs to be relieved as well. Thank you for the opportunity to meet with the panel, and I urge you to move ahead as soon as possible in this effort. Thank you.
Okay. Thank you, Mr. Cooper. Let me turn